Center. I welcome you all the participants, the coordinator of the DPIIT IPR Chair of GLU, coordinator Anama Samuel, and our today's speaker Sushant Samudrala sir. Before we start the session, first just excuse us due to the heavy rain in Rajkot and Ahmedabad, maybe some network problem is arise. So please excuse for us. We will try maximum to solve this problem. Now I would like to introduce our today's speaker, Sushant Samudrala sir. Advocate Sushant Samudrala is a cyber law expert and techno-legal concern. He is the CEO of Sushant IT Law Associate and niche cyber laws consulting firm working in the area of intersection of law and technology. He is an advisor speaker and has addressed more than 1,200 events in the last decades. He is an academician and as a regular columnist to a various newspapers, including the Daily Guardian. He has written more than 7 ebooks on a various facts of technology and law. He has published various articles on law and technology in international journals. He has received more than 30 awards from various international national organizations, government for his contribution to cyber law. He has been advising companies across the globe, including US, UK, Middle East, South Africa, Nigeria, Singapore, Malaysia, Thailand, France, China, Japan, Australia, and many more. He is a visiting faculty to many premier institutes and regularly trains the law enforcement agency across the globe, including Cambodia, Sri Lanka, Singapore, Thailand, etc., on technology law matters. He has trained more than 1 lakh stakeholders in the different domains of cyber law, cyber laws, AI, blockchain, crypto, gaming, fashion, technology, e-commerce, mobile law, social media, 3D printing, gas, computing, and many other things like that things. He has also mentored startup at legal matter pertaining to technology and has launched an awareness platform named Startup Legal Connect. He hold a master's in cyber law and cyber security and certification in cyber security incident response, cyber law, compliances, audit, network pan test, e-commerce, IPR, cyber crime investigation, cyber crime analysis, digital evidences analysis. With this brief introduction, I would like to welcome Dr. Sushant Samudrala to deliver his talk on IP enforcement. So please.
Thank you so much, madam. I hope my screen is visible.
Yes, your screen is visible, sir.
Screen is visible, but speak loudly, sir. Voice is very slow.
Okay. Now is my voice better?
Yes, sir. Yes, sir.
Okay. Thank you. Thank you so much, please. So good morning, all participants. So it is once again a very interesting day to start off today. I thank the organizers for this wonderful opportunity and for helping me to come and actually deliver this talk to you virtually. So I have a very interesting topic today, which is known as IP enforcement. So I have tried to bring in some practical perspectives as well, because I'm sure that a lot of times you would have actually come across matters relating to intellectual property from an academic perspective, but I would like to also add practical views of the same, because I deal primarily with the intersection of law and technology. So I also thought I should give in some practical understanding and perspectives given the latest and emerging trends of technology that we are all part of today. So the whole endeavor today is not to just talk to you from an academic perspective, but also to give you the overall understanding of the IP enforcement and the challenges, the laws, some interesting case studies, and also take you across through the different kinds of IP related enforcement aspects relating to emerging technology. So this is the endeavor of my presentation today. So I have some very interesting and very filmy kind of slides just to bring in the perspective in a more lighter manner. So I thought I just give you this background before I get into my presentation, and I'll be more than happy to take any of your questions at the end of my presentation. I would love to interact with you and have some interesting deliberations, because at end of the day, I believe that we should pick up some value out of this program. You know what happens usually is that these universities and these colleges, they're becoming more and more rich in terms of knowledge. Why? The reason is they organize webinars and sessions like these. And why I said they're becoming rich and rich in knowledge is not just because they organize these kind of talks, but because as a speaker, I come with some knowledge, or the speakers come with some knowledge. As participants, you come with certain knowledge. But end of the day, all the knowledge gets deposited in this conference hall. So therefore, I believe that we should pick up some value so that we can derive the benefit both mutually, you and me, both of us. So that is something that I believe in inclusive growth. So with this short introduction, I would like to get into my presentation, please. So this is the usual response I get when I'm taking a session, especially when it's a rainy day, as we have a very good climate today, and I'm sure if I switch on the videos and of all the participants, I think most of your faces will be like this. So let me see whether I can try to change this expression as we discuss forward. So this is a very famous thing, in this Bollywood movie called Satya, which was way back in 2000s, directed by this filmmaker RGV. So he's a very popular filmmaker, and then very interesting dialogue. If you look at what's there on the screen, where whoever raises the hand because they are all into this mafia and all these kinds of activities, so underworld activities, so they become the first owner. So likewise, whoever registers for any intellectual property right in the first instance becomes the owner of that particular intellectual property right. So that's the basic principle of my presentation today. Though registration is not mandated, but I would like to talk to you about the challenges as well as the pros and cons of registration of IP, so that that could be one of the methods that we could look at with respect to enforcement of IP rights. So this is something interesting that I thought I should just start with. So as you probably are already aware, I'm not getting into the basic pointers, but just to tell you that there are lots of forms in which you can protect your intellectual property, because anything and everything that you do probably generates and creates certain kinds of intellectual property. As we are having a webinar and session today, even there's a lot of intellectual property that is getting delivered out of these session today. And it is very important that you actually protect these kinds of intellectual property. So basically, when you look at how do you protect the intellectual property, there are different forms of how you can protect your intellectual property: trademarks, copyright, patents, designs, geographical indicator, and semiconductor layouts and plant breeder rights. I'd also like to tell you, we also have trade secrets. So these are different forms available with respect to protection of intellectual property. So in a nutshell, I'll just give you a small understanding on how these can be protected. For example, let's think that since you're all into the incubation center and innovations and things like that, I just give you a small example. Let's say that I have a concept. I come up with a business idea, and I think that business idea is going to be very, very good. It's going to be a game changing element. So therefore, what's the first thing that I will look at? I'll first try to document, I'll try to protect, and I'll put whatever idea I have into the paper. So the moment I put anything on the paper, that becomes an intellectual property right. Why? Because it's executed. So merely sharing ideas will not be legally protected. So I will have to execute the idea. So that's where the point is. Execution of ideas can be protected, but merely sharing the ideas cannot be protected. So the first thing that I would be looking at is to document my idea, to give it a shape and form, so that I'll be aware of how to proceed further. So therefore, as a first thing, what do? I come up with a business plan. I draft out a business plan. So this business plan is an intellectual property because it's in the executed format. So how can I go ahead and protect this business plan? It's a piece of document. So therefore, it's a literary work. So just like you have all these novels, books, and your research papers and things like that, you can go ahead and protect this as a literary work. Now you will say, how do I protect literary works? Now that is where copyright comes into picture. So copyright protects literary work, artistic works like paintings, drawings, and things like that, and also cinematographic films, musical recordings, sound recordings, and also something which is relating to computers. So we'll talk about computers and computer programs as we discuss forward. But just to tell you that copyright is something that protects literary right, literary works, artistic works, dramatic works, cinematographic works. That is something to do with sound recordings and also computer programs. Now, after this, what do? You go ahead and call out a name for your idea. So you try to have your own branding. So for that, you require a brand name. And for that, you also come up with a logo. Why do you have this logo? Because we would like to have a identifier. So how people, when they look at a particular brand name or a logo, they'll be able to identify and relate. Just like if you look at any other brand today, say Apple or Samsung, you'll be able to quickly relate the moment you look at the logo. So how are logos and brand names protected? That's where trademark comes into picture. So trademark is an intellectual property right, the one form of intellectual property right that protects uh, logos and brand names. So let's go to the third one. I come up with, okay, now I have theoretically put it on the paper. I've also given a brand name. Fantastic. Now, what is the next thing? I will have to execute. Suppose when I'm executing my idea, let's say that I come up with a certain process or a certain kind of an invention. Then how do I protect that invention? How do I protect that particular flow? That's where patent comes into picture. So I will have to go ahead and seek a patent. Patent is one form of intellectual property right that usually is granted for inventions, discoveries, and things like that, processes. After this, what happens? I come up with a design. I start designing. If my work requires some physical design, maybe 2D or 3D designs, then I will now be required to also go ahead and register a design. So we have the Designs Act in place. So I can go ahead and register my design. Now, what's the next thing? Geographical indicator. Let's say that my invention, my idea relates to a particular place, geographical place. So for that matter, let's say that I'm coming up with some innovation, and I believe that okay, let's say Ahmedabad is something that's popularly known for this kind of an raw material. So therefore, what do? I go ahead and seek a geographical indicator. So geographical indicator, as the word itself suggests, it's going to describe the geographical region. For example, Hyderabad biryani. So that means there's a name, the geographical name. So we have a lot of things that are there, but common forms are something that quickly gets into your mind. Is something that we always talk about is food. So that's where I brought up the example of Hyderabad biryani. So that can be a classical example of geographical indicator. Why? Any biryani is different. Hyderabadi biryani is different. Why? Because Hyderabad is famous for biryani. So therefore, the geographical territory of the place is again used as an intellectual property, which is Hyderabadi biryani, geographical indicator. Now, semiconductor layouts, yes, when you arrange a particular, the circuit and the, conductors, layout of the circuit that you actually, try to build in, that circuit design also can be protected. How? You can go ahead and register it under the Semiconductor Layout Designs Act. Now later, plant breeder rights. This is something to do. Not much of things are there in India, so I'm not getting too much into that. But that's something to do when you have come up with a hybrid plant variety. So this is something which the agricultural companies or the organizations in the agriculture and farming do adopt. So these are basic forms of intellectual property protection. So as a business, the organization or any company or any individual, you'll have to primarily look at three things: copyrights, trademarks, and patents. So these three will be playing a critical role when it comes to the practicality. So therefore, let's look at them and let's try to understand how these could be enforced uh, with respect to your intellectual property rights. Okay. So as the word itself suggests, what is IP enforcement? Why do I require, something on enforcing my IP rights? Yes. Now, when you go ahead and create an intellectual property, there are obviously going to be certain rights that you'll be given. And when are these rights going to be possible? When you go ahead and register your intellectual property. And when you have intellectual property in your name, then what happens? When you own an intellectual property, there are certain rights attached to it. So therefore, the ability to enforce the IP rights is nothing but the IP enforcement. And apart from that, how do you protect your IP also forms an essential component of your IP enforcement. So it's very important that you are aware not just about the enforcement angle, but you should also know how to protect it, and then what are the rights available to you, then you will be able to enforce them better. Because unless and until you are aware of this, there's no point in going ahead and talking about the enforcement. So enforcement is the next phase. So I would say at the initial phase, you should be aware, register your IP, protect your IP by way of registration, then go ahead and understand what are the mechanisms to enforce your rights. So this is in short my presentation today. Yeah. So when you look at the registration of an intellectual property, especially copyright, trademark, or patent, why I'm just talking about trademarks and copyright here and not patent, I'll just give you an explanation about that. Well, there is no uh, mandate or a compulsion to go ahead and register your intellectual property. Now you will say, why should I register my intellectual property? Yes, there comes the question. So let me tell you why registering of intellectual property becomes important. The first and foremost reason is it acts as an evidence. So tomorrow, should there be any kind of ownership claim that you would like to make, this is a legal piece of evidence because it is given by an authority and we have a legislation backing up the same. So therefore, that's the primary advantage that you likely to have. Second, it gives you enforceable rights. So that's the second aspect. Until and unless your intellectual property is registered or you make an attempt to register it, you would not be having able to effectively enforce your IP rights. Otherwise, also you can enforce them, but not in an effective manner. Third, in case there is a litigation that is taking place tomorrow, should there be any problem, then what happens? The burden of proof shifts upon the other party and not upon you. The legal presumption is you own it. Unless somebody disputes it, there will not be any kind of a issue at all. So the legal presumption is upon you that you own the intellectual property, and the burden of proof is shifted to the opposite party. So these are primarily some reasons why registration is mandated. Now let me give you an example. This is one of the cases that had come to me when we were actually trying to fight for a rice trader. Okay, let me give you this example. As you know, West Bengal is very popular for rice, and we had got a rice dealer who was there from almost 30 years down the line, supplying rice in a particular kind of a packaging model. For example, the rice bag, the color combination, the kind of identity. All these are very peculiarly maintained. For example, anybody looking at that rice bag was immediately able to relate to these people because they were into the trading business from more than 30 years. So what happened in this case? One fine day, they realized that these people packing was duplicated. And what happened? These people usually are known for maintaining very good quality of rice, but lo and behold, they got a shock of their life when they realized that somebody was actually trying to imitate and come up with similar packaging for a very, let's say, one fourth of the price of what these people were selling. And let me tell you that the material being sold was a very inferior quality. So therefore, what had happened in this case? Very simple thing that this was already identified by the local people because of the way in which the packaging was done. So people obviously thought and related to this 30 years rice dealer, but did not relate to the duplicated party who duplicated it. So what happened in this case? There was no intellectual property registered, no trademark was filed. Okay, they wanted to seek a legal recourse because it's their intellectual property that's been breached, and as a result, they started incurring reputational issues as also they started facing damages by way of loss because nobody actually tried to go and purchase because they had spread the rumor that their quality has come down and they're supplying inferior quality at a low price. So how do you tackle such issues? So therefore, it was a very big challenge for us. Of course, we established the fact with evidences that this is their packaging material. We had witnesses, and all these things were brought by us to the court of law. But lo and behold, it took almost 1.5 years for us to get a successful injunction order restraining the other party from using the similar packaging material. But what's the underlying principle here? The underlying principle is okay, I need not mandatorily go ahead and register my trademark, but if a trademark would have been registered, that would have eased the process, and I would have got all my uh, legal recourse done in a very short span of time. I wouldn't have taken 1.5 years to fight and get successful injunction. Well, all this process would have been eased, and I would have got immediate legal recourse. So that is the principle why registration of intellectual property becomes very, very important. So this is something that I thought I should share with all of you because it is not mandated. Still, in this case, like in this case, you could also be successful in getting a legal recourse or an injunction order in the favor of any individual or an organization without registration as well. But all that I'm trying to tell you is, if it is registered, it gives you a better advantage. So that's the whole reason why I thought I should just talk about this particular case. Now, when it comes to trademarks and copyright, you'll say, what is the procedure? How long will it usually take? Let me give you an instance. For getting a trademark, you may roughly have about say 1 to 2 years it may take for you to actually get your trademark registered. But what happens in these 1 to 2 years if somebody violates or breaches or infringes on your trademark? How do you enforce your right? That's the question that you're going to ask. Okay, it's a very simple case. Now, the moment you file your trademark application, that will cost you somewhere around say 6 to 7,000 rupees per class. And what happens there after this? Once you file your application, you can use the name, uh, you can use the term rather, TM beside your brand name. So you might have seen a lot of brand names use the term TM. What does it mean? It means that, hey, look, I've already filed my application in the trademarks registry, and should you wish to do anything, I have my legal recourse. So that is the exact connotation of the word TM. So therefore, TM signifies that I have already done part of my registration, and my registration is in the process. So the moment you file your trademark application, you can enforce your intellectual property rights. How do you do that? Now let's say you have filed your trademark application and now you start using the word TM. Later, you find that somebody is actually trying to make use of your same brand name and logo and things like that. How do we enforce your intellectual property in those cases? You can send out a legal notice, which is called a cease and desist notice, as a first step to actually curtail them from using your intellectual property right. So you can enforce your IP by way of this notice, which is called cease and desist notice. The word itself says cease and desist. That means you cease to use this from immediate effect. So you're trying to convey to the other party through this notice that, hey, look, I've already applied for registration. My registration is under process. But however, you better not use this, and you cease to use that with immediate effect. Failing which, I will have all the legal recourse against you. That's the first line of defense. Now, what's the next way? You can also go ahead and seek an injunction order from a court of law, specifically restraining the other party from actually utilizing the same logo and brand name. So this is still being made available to you from the day you file your trademark. You don't have to wait till the time your trademark gets registered. You can start with an interim protection by way of sending out these notices and getting an injunction order right from the time that you file your application and get an application number. So this is the fabulous advantage that the trademark law gives you. Now, let's look at copyright. Now, the moment you file your copyright application, you're given an application number similar to what trademark has. And from that day onwards, you can start using the copyright symbol, which is circle C, in your work. Now, same thing, should there be anybody who's trying to infringe, breach upon your copyright, till the time your copyright gets registered, lo and behold, you can now knock the door of the of your legal rights, enforce your legal rights by way of sending out the same notice as also getting an injunction order from a court of law. So these could be the what can I say, the enforcement options made available to you interimly or in the interregnum period of uh, getting yourself into a registered trademark or a registered copyright. So you don't have to wait till you get the copyright or the brand trademark registered. You can start enforcing your rights the moment you file your applications. But however, this is not the case with patents. Why? Because the patents concept is entirely different. So until and unless your patent is completely granted, you may not be able to enforce your legal records in this manner as you are able to enforce with respect to trademark and copyright. So that's something that we'll have to consider. Why? What's the reason? The reason is at the last phase of your patent, have a, you have something called a patent claim. So if somebody's claim is more better, more reasonable from a legal perspective than yours, your patent will be rejected. So what's the option? That's the reason in the interregnum period you will not be able to exercise effective legal remedies. So therefore, this is out of the practical experience that I'm just trying to tell you. So therefore, please remember that these would be very, very effective remedies which the law gives you to enforce your IP rights, especially during this interim or interregnum period of filing and registration. Between the time that you file your application and till such time you're granted registration, in this period, you still can enforce your intellectual property rights. So this is something I just wanted to instill upon you because this is from a practical perspective. So therefore, I am sure now you appreciate the advantage that you have with registration, and also you understand and make use of these legal remedies and also the IP enforcement mechanisms that you have now between the registration, that you have during the phase of your filing the application and you getting the application registered. So I hope you got some understanding about the same. Yeah, so this is what I was just trying to talk to you about. So if it is registered, yes, legal evidence, monopoly, and of course the burden of proof shifts to the opposite party as well. Now, one of the very interesting things that I would just like to talk to you about is that one of the ways how the intellectual property rights could be enforced, especially on the social media domain or on the OTT platforms, is given under the new guidelines 2021. I think there's some. Could you request the other participants to just mute your microphone, please? Thank you. Yeah. Now, one such option that's now given to you because today social media has become center of our lives. We're using social media left, right, and center for different activities, personal, professional, social kinds of obligations are now being exercised. Now, in this domain, how do you protect and enforce your intellectual property rights, especially on the social media platforms? Before I get on to that, I would like to just talk to you about something known as the cyber law. So in India, we have a cyber law, which is known as the Information Technology Act, and it was here introduced in the year 2000. So it's a new generation law. It's hardly 22 years old, and we also have the rules and regulations introduced in compliance with the IT Act. So the IT Act was introduced in the year 2000. It was amended in the year 2008. Then We also had come up with IT rules 2011, on April 11th, 2011, and recently we are now actually trying to come up with new regulatory frameworks which are by way of these 2021 IT rules basically. So I just would like to tell you that the new rules also bring in the concept of protecting and enforcing intellectual property rights across the social media domain. Now let's just understand how we could be enforcing the intellectual property rights in this domain. When you look at the IT rules 2021, rule number 3, it very clearly brings in the concept known as due diligence. And first, let us understand what's an intermediary. Until we had the IT Act amendment in 2008, all of us thought. Could you please mute your microphone, please? Thank you. Until 2008 amendment came in, so we were only talking about intermediaries in the context of telecom service providers or internet service providers. Now, the time has come when you need to expand our thinking horizon. Now, the Information Technology Act 2008, by way of Section 21W, had come up with this new concept known as an intermediary. Now, who's an intermediary? Well, any person who, on behalf of any other person, either receives, stores, or transmits any electronic record or provides any service with respect to an electronic record. Okay, that's the legal definition of an intermediary. Now, in a nutshell, what's it? If you are an individual, or if you are a company, or if you are any kind of an association, no problem. If you collect information in the electronic format or the digital format, then you provide any service with respect to that information, you become an intermediary. So, given this scenario, any website, any mobile application is an intermediary. Even an educational institution, a university, is also an intermediary. Why? Because they're collecting your information and they're providing you this webinar as a service, which is obviously going to be, we are all given, certificates, and we are all given, some kind of information is collected. The link is shared to you electronically. So even the organizers of this conference also is an intermediary, given this definition. So please understand, even social media companies, Facebook, Twitter, LinkedIn, Instagram, are also intermediaries per se. Now, when you're an intermediary, you will have to exercise due diligence under the IT Act. So what is a due diligence? So now the new rules have now come up with something known as rule number 3, which talks about due diligence. As part of that, they are not supposed to display, post, upload, modify, publish, transmit, store, update, share any of these material. What is this material? Anything that belongs to any other person of which you do not have any rights, anything that is defamatory, privacy. I mean, I'm not getting into this, but what becomes very, very important is the first one that you're able to see on the screen, IP, which is the intellectual property of someone else. So should any social media be displaying, posting, transmitting, sharing, publishing any information that is the intellectual property, that is affecting the intellectual property right of any individual or a company, that would now be required to be removed and disabled. So we have a timeline for it. I'll also discuss with you about that. But just to tell you that now you don't have to worry, because the law has now been given. The law has now given you a enforcement mechanism to actually enforce your IP rights on the social media. So should your content, should your intellectual property right, should your trademark, should your copyright, should your patent, should your design be uploaded upon any of the social media platforms today, you can exercise your IP rights in an effective manner through this particular IT rules 2021. So just let me tell you how. If you're an affected party, you would now be required to bring notice to this particular intermediary. Now, who will be the person who will be responding on this particular notice? So how do you send out this notice? Well, if you're an affected party, if you're an owner of an intellectual property that's been breached, infringed on the social media, the effective mechanism that you will have to now look into is every intermediary is now supposed to appoint a grievance officer. And the grievance officer would be required to actually address your grievances. Now, the first thing that you will have to do is look at the grievance officer's details, and intermediaries are now mandated to publish and make available the email IDs, the names, and the contact details of the grievance officer. Now, you can drop in a mail to the grievance officer directly stating your concern of how the intellectual property right was infringed and how it affects you as an IP owner. So, therefore, they will have to acknowledge your grievance within 24 hours, and within 36 hours they'll have to take down that content and internally do an investigation. Now, should they not be doing that, they could be accountable to civil and criminal liabilities per se. So the point is very clear. The law has now given you a very effective mechanism when it comes to grievance. Apart from that, there's also now a concept known as significant social media intermediary and a social media intermediary. Now, who's a social media intermediary? Any intermediary whose only business is to provide communication links between two or more people is a social media intermediary. So Facebook, Snapchat, WhatsApp, YouTube, uh, and any social media platform is a social media intermediary thanks to these new rules of 2021. We also have somebody who's known as significant social media intermediary. Now, who's significant social media intermediary? Officially, there's no clarification relating to that, but there'd been one clarification given on the website by the government stating that should any intermediary have more than 2.5 million users or registered subscribers, they would be considered as a significant social media intermediary. Now you will say, what has IP rights got to do with significant social media intermediary? Well, it's very simple. If you are a significant social media intermediary, you are now required to appoint chief compliance officer and nodal officer and a grievance officer. And the nodal officer would be the person who would be handling any kinds of grievances now. Now, when you look at all these social media platforms, their nodal officer details, the contact names, people, the name, the phone numbers, and the email IDs are also now being published in the public domain. You can go ahead and Google it, Google the nodal officer details of these platforms. And what do these nodal officers do? They will act 24 into 7 with the enforcement agencies now to provide them with all kinds of information and support that is required thereof. So gone are the days when you say that I do not know whom to report in case my IP is violated on the social media. And one of the major things that the guidelines have brought in is all these people should be resident Indians. So what does it mean? There must be an Indian citizen who should be appointed as a nodal officer and a grievance officer per se. So gone are the days when you go ahead and struggle yourself to actually submit your grievances or report it to Facebook. Facebook takes its own sweet time to actually react. That's not the case. Now, rule number 3, subsection sub-rule 2 mandates that they will have to act and take down within 36 hours, failing which legal liability by way of criminal civil could be cast upon the social media platforms. So this is how you will be able to effectively enforce your IP rights on the social media platforms. So I hope you got an understanding about the same. Now, we also have in it one another mechanism to enforce your IP right. What is it? It's known as John Doe order. Now, what do you mean by John Doe? John Doe is unknown. What usually happens is we effectively know against whom we want to procure an infringement or let's say an injunction order. Let's say that a particular website, a particular mobile application actually tries to host any content. What happens in that scenario? You go ahead and seek an injunction order against that particular. You go ahead and seek an injunction order from a court against that respective service provider of that particular website or a mobile app. What you'll have to keep in mind is on the internet, we do not have any idea where all your intellectual property will be infringed. So that, excuse me, I think I know I had a call. Just let me just present my presentation back. Hello, am I audible again?
Yes.
Is my screen visible?
Yes.
Yeah. So usually, we know that a particular website or mobile application or a particular platform has infringed upon our IP rights. So to, enforce our IP right, what we do, we go ahead and file a case against that particular platform provider. But on the internet, it's a very, very difficult and a challenging aspect because you are unaware which website or which platform or which mobile application on the internet would be able to actually will be sharing out your will be breaching your intellectual property. So in that sense, it is so difficult to identify the opposite party. So that's where we have the concept known as a John Doe order. So John Doe is someone who does not have any identity, whose identity is not known to us. In India, we call that as Ashok Kumar as well, but Ashok Kumar order. But I don't think that name has got popular. But in the Western countries, John Doe means unknown. So you try to seek a blanket protection order from a court of law by way of this John Doe order, where you enforce your IP rights across any platform or any website or anything that is available on the internet. So, should anybody be breaching or infringing upon your intellectual property right, that particular platform will now be brought under the legal radar, and there would now be contempt of court proceedings initiated against the platform provider for violating the same. So therefore, this is the concept known as a John Doe order. Apart from this, two cases that come to my mind when I talk about John Doe orders is these movies that you're able to see on the screen, Bodyguard and Singham. The producers of this film actually went up to the Delhi High Court and sought a John Doe order restraining unknown parties from actually offering, downloading, facilitating the download of these movies across the internet. I do not say that completely they were able to eradicate piracy, but I'd say online piracy was controlled in a certain manner thanks to the John Doe order being available. So this is one effective IP enforcement mechanism that you can make use of to enforce your intellectual property rights on the internet per se. As you know, software piracies are spreading around left, right, and center on the internet with all kinds of malware, spyware, and computer contaminants. We also started to see different kinds of attacks, like the ransomware attacks, which has become the new jewel in the crown, even in this COVID-19 era. So therefore, you know, the legal remedies have already been sought for software piracies as well. And in this case, the Delhi High Court has awarded 30 lakh damages to Microsoft uh, and Adobe and other softwares, restraining a company which is based in the National Capital Region from using, distributing the pirated and unlicensed softwares. So this is how legal recourses, legal remedies are being made available even in case of software piracy. So this is something that I just wanted to discuss with you. Uh, Copyright protects computer programs, and we'll also look at how computer programs could be effectively protected by way of copyright. Yes. Now on the internet, there are going to be a lot of piracy related issues, especially on softwares and tools. Counterfeiting, internet piracy, end user piracy, client server overuse piracy, hard disk piracy. A lot of these kinds of piracy issues are happening upon the internet, left, right, and center. Counterfeiting is fake internet piracy on the internet, end user piracy, piracy happening at the level of end user. Client server, of course, you're trying to make use of client server for piracy activities. Hard disk, of course, another kinds of piracy issue. Now, how do you effectively implement this? Now, the Copyright Act usually monitors any kinds of piracy activities and provides punishment thereof. And apart from that, the IT Act also now, by way of Section 43 and for, Section 66, gives you the civil and criminal remedies for enforcing your intellectual property rights should there be anything that is unauthorizedly used. Let's look at that first. And how do you determine the compensation under with respect to any of these penalties? uh, it is usually depending upon some factors, the amount of gain or the unfair advantage, if it is quantifiable, which is done as part of the piracy or default, amount of loss that you incur because of the said breach, and if it is repetitive in nature, yes, what could be the challenge? So these three elements will be looked at by the court in order to effectively grant compensation for your intellectual property violation. This is your civil remedy. Now, Section 43 of the Information Technology Act also gives you an effective remedy, which is by way of, Section 43, unauthorized access. Now, anybody accessing or securing access to a computer in the sense that any device which basically has three elements. What are the three elements required to call a device a computer? Memory, arithmetic and logical unit, and number three is the ability to store and respond to your instructions. So memory, arithmetic and logical unit, and the capacity to understand and follow your instructions. if any device has these three elements, it can be called a computer. That means your mobile phone is a computer. Your smart devices, smart television, smart printer, Wi-Fi printer, your tablet, all these are computers under the IT Act. If anybody downloads, copies, extracts data, look at this. So anybody who's downloading, copying, extracting data, which is again having intellectual property attached to it. Therefore, that's the reason this I just brought this also into the discussion today, and that could also be something that you can effectively enforce to get compensation under the Information Technology Act. So Section 43 is something that you can make use of, and apart from this, you also have Section 66, which is a computer related offense. Should there be anything which is relating to violating of intellectual property right, especially for your digital content or content in the electronic form, and if it is done with a dishonest and fraudulent intention, then you could also exercise you know uh, remedies under Section 66, criminal remedies under the Information Technology Act. So what I wish to instill is, apart from the copyright law, you could also make use of the Information Technology Act uh, provisions, both 43 for civil and 66 for criminal, for intellectual property rights enforcement. And apart from that, you could also sue the respective person under Section 66B for using a stolen computer resource, or a stolen communication device. Should you have any data on your communication device, obviously on your mobile phone, on your iPad, on your tablet, or any of your computer resources, your network, your server, your USB drives, your hard disks, your let's say computer, no, any kinds of flash devices, all these things, should anybody make use of this by stealing it, indulging in theft, they will not be just accused of theft, but they'll also be accused of data theft, and there'll also be intellectual property violation in that regard. Therefore, you can also use 66B of the Information Technology Act. Now, let's look at a computer program. Now, when you talk about a computer program, the copyright law also has provided something which is talking about piracy of a computer program, which is known as infringing copy. Now, how is an infringing copy defined? Any copy that is made without any permission or license granted by the owner of copyright, that copy becomes an infringing copy. So if you make any copy of any material, which is a photograph, a video, an audio, or a book in the electronic format or in the non-electronic format, without proper license or permission from the owner of the copyright, that particular copy is known as the infringing copy. So therefore, any pirated software, any pirated app, any pirated content becomes infringing copy according to this definition. And what's the remedy? You can go ahead and exercise remedies under the Copyright Act to enforce your IP rights by way of Section 63B. 63B specifically talks about anybody knowingly makes use of an infringing copy, that becomes an offense. So be very careful that anybody who's even making use of a pirated Microsoft Office, Microsoft Windows, is also now brought under the radar of Section 63B, because you are very well aware that it's an infringing copy. So therefore, the punishment is very simple. I mean, 3 years, 50,000 rupees, and it could extend up to 2 lakh rupees. Yes, but you would be now charged under this particular section. Now, the computer program also, which is now duplicated, it covers under this particular ambit. So therefore, explicit powers have been given under the Copyright Act for the police to actually go ahead and seize this infringing copies, so that your work is not again affected. So as an intellectual property rights owner, you got even the legal recourse of exercising and preventing further damage by under this provision, where the police will be able to seize the infringing copies. These kind of remedies are known as administrative remedies. We'll discuss about that as well. So 65A of the Copyright Amended Act also protects the owners of copyright in case of breach. Anybody who violates an effective technology measure which is used for protecting. This is again another mechanism. Now, to enforce your intellectual property rights with respect to digital content, there are various technology measures that you use. Let's take an example of a DRM, digital rights management. So, the classical example that you can look at is a watermark, a digital watermark. That's a classical example that you can look at. So, you just try to imagine if you try to copy any video or any program, there's also the what do you say, watermark in the background that will get copied. So therefore, should anybody circumvent is nothing but bypass an effective technology measure that is used for protecting the intellectual property right, then that also now is covered under this particular section, and punishment has also been prescribed hereafter. So apart from this, yes, you removes, alters rights management. This is what I was just trying to tell you. Distributes, imports, or broadcasts. This is another very interesting example. So therefore, digital content is also now effectively, the violations for digital content also is now being quite effective thanks to these amendments in the Copyright Activity. And you could couple them with the Information Technology Act. Should there be data or information in the electronic format, any video, any audio that is even shot unauthorizedly without proper license or permission from the owner of the intellectual property also gets covered under this ambit. So you can enforce your intellectual property rights by way of IT Act as well as the Copyright Act. So I'm not getting into all of these, but just trying to tell you. Yes. So in this case, Adobe Systems versus Sachin Naik, the Delhi High Court ordered for damages by way of compensation of 2 lakh rupees against 33 pirated versions of Adobe software by this particular company. So therefore, the fact remains is that should there be any kinds of pirated versions of computer programs or softwares, you can effectively enforce your IP rights by way of filing an injunction order in the court of law. You can file a criminal case. You can exercise your civil remedies by getting compensation by way of damages. So these are the multiple options being available to you. Now, usually what happens is softwares also have these concepts of the terms and conditions. When we accept it, there's also a contractual remedy that has been made available here. So when I offer anything to you as a service, let's say I'm delivering a digital content to you as a service. Apart from intellectual property, there's also an element of contractual remedy that I can enforce upon the same. So it's three options have been given. One is look at the copyright laws and the traditional IP laws. Second, you look at the IT Act. Third, you can also look at the Contract Act for legal recourse. So these are the different options being available to you for enforcing your intellectual property right. And another way to enforce your intellectual property rights is incorporate them, have proper IP protection clauses in the contracts and the license terms so as to ensure that your IP rights could be effectively enforced even for a breach of contract. In this case, of course, copyright violation, 3 million INR was granted as compensation here. So therefore, that's another case that I was just wanting to tell you. So all these are something to do with the internet. So I'm not getting much into it, but just to give you a legal snippet of the options that has been made available. Yes, and please understand that even the use of these softwares, you should also look at what is the kind of license that you purchase. If it's for home, it's a different matter. If it's for a corporate use, it's a different matter. And then if you're trying to use it in a different manner, you purchase it for one, you use it for another, then probably that will also be something that will be considered as a breach. And therefore, at any point of time, you can also go ahead and exercise your legal recourse. So what could be the issues that you could look into with respect to software piracy, audit, evidence, all these things could also be something that you can look at. So civil remedies, damages, criminal remedies by way of sending someone to jail, arbitration. You could also look at arbitration for enforcing your intellectual property rights in an effective manner. So specifically, criminal liabilities in case somebody infringes your intellectual property right, criminally, then you can probably look at, running behind uh, uh, the sections of uh, Copyright Act, as well as you can bring in Section 85 of the IT Act, to also bring in the company, people who are running the company, managing the company, and each and every responsible person who's responsible for the day-to-day affairs of the company could be brought in. So what's an exception? Exception is when they're able to establish that they have taken due diligence and it is taken beyond their control, then they will be exempt from any kinds of legal liability. So not getting into this search and seizure, but just to tell you that police have now been given authority to conduct search and seizure, and this is an administrative remedy. So what usually happens is, apart from civil and criminal remedies, you also have administrative remedies. Administrative remedies is when you try to get the police to seize these infringing copies, because these infringing copies still continue the violation or breach of their intellectual property rights. So that's very, very important. And what police do, they deposit all these infringing material in the police station, and they also try to seize that. They hand it over, they either dispose it or they hand it over to the rights holder, because they do not want the further copies to be done. Therefore, so these are all the remedies that you have. Civil, criminal. Civil is when you want to get damages by way of compensation. Criminal is when you want to send that person or the organization to jail. And administrative remedies to get the what do you say, infringing material seized and handed over to you, or to the destroy the infringing material per se. And I would also like to talk about the IP enforcement with respect to some latest emerging technologies like artificial intelligence, blockchain, metaverse, and platforms like these. Just trying to walk you through some of them. So this is what I was talking to you about: civil, criminal, administrative. Civil infringement, passing off. What is passing off? When you deceptively make use of an intellectual property right. Let's say, for example, a trademark. You know that a particular company trademark is there. Let's take Adidas. Adidas, somebody made a brand name called Adibas, Adibas, which is almost similar to Adidas. And they came up with the caption saying that this is a new brand of Adidas, and they are providing new kinds of footwear and apparels for lesser price. So therefore, a lot of people fell prey for it. So therefore, in that case, they're deceptively making use of the trademark. They're trying to cheat people. So therefore, there's an element. If you're able to establish that there is a dishonest and fraudulent intention, that is intention, then that could also be a criminal case, or else you can also seek remedies by way of compensation, which is under the civil remedies per se. So administrative remedies, you could get those infringing material handed over to you or destroyed, so that there is no further damage taking place. Civil, yes, injunctions, damages again for loss that you suffer, for the for any kinds of raids and seizures that could happen from the police or enforcement agencies. That the administrative remedies, I was just talking to you about, injunction orders as well. Apart from this, ex parte orders could also be something that you could look at, John Doe orders and things like that. Then you also have effective remedies which are also been there. For example, you have damages on the account of profits as well. So therefore, that's an equitable relief again. So account of profit. Injunctions, permanent injunction and perpetual injunction. You have ante and pillar orders as well. Ante and pillar orders are something which are similar to ex parte orders. And what the court does in this case is, the court order provides for the right to search a premises and seize the evidence without a prior warning. This is what I was talking to you about, raids and seizures. And specifically, why is this done? It is done to prevent the destruction of evidence, prevent all of these things, especially when there is an involvement of any IP, like trademark and copyright. And these are very sensitive in nature. So therefore, that is the reason why these ante and pillar orders are also being granted. So that's first time it was granted in the year 1976. And what becomes important is, there must be a strong prima facie in this particular case. And damages would also be something that will be looked, actual versus the potential. Therefore, what is very important is, this is also something that you can look at, apart from just seeking your injunction order. John Doe orders, ante and pillar orders, ex parte orders could also be something you could look at. Damages by way, I mean, account of profit also something that you can look at. And yes, you could also now look at, getting yourself damages under the IT Act as well, basically, apart from the copyright law. And criminal remedies are also there. You can look at, the criminal remedies. This is one another case where interim or interlocutory remedies could be made available, especially uh, to maintain the status quo. Time would be something that will be very, very considered as an essence. And what could be the real remedy that you could look at? If you want to seek an interim order, these are the three elements that you could look at. First of all, there should be an irreparable injury. In case the injunction order is not granted, there should be, a prima facie. That's what a matter that, involves any kinds of, violation or something that really infringes upon your intellectual property right. Balance of convenience. All these three could be something that you would have to look into, specifically in case you want to seek an interim or interlocutory order. And this was very well established in this case called Gujarat Bottling Company versus Coca-Cola. The citation is already stated thereof. Even domain names now could also be now effectively be enforced. Any rights which is attached to domain names could also now be looked at, because the Supreme Court in these two cases has come up with distinctive judgments. One in the case of Satyam Infoway versus CIFINET, where the Supreme Court held that domain names are also subject to legal norms which are now being applicable to other intellectual property. So whatever are the legal norms that are applicable to intellectual property rights, like trademarks, patents, and copyrights, could also be applied to domain names. So uh, should you effectively want to exercise your IP rights with your domain names, because domain names are very, very important in today's world. So therefore, you can go ahead and enforce the same. And apart from that, in this case of Yahoo Inc. versus Akash Arora, the Supreme Court also applied the general trademark law to the internet. So should there be any kind of trademark related infringements, passing of activities happening across the internet, you could also look at this case as a precedent and apply the legal remedies, civil, criminal, and administrative per se. Metaverse is something that's now become the center stage, shall I say, eye candy on the stage in this uh, technology era. So you also already started to see metaverse where digital platforms, digital worlds, digital characters, and digital assets are now being made as fundamental premise. So digital avatars of people, it's no longer a Hollywood approach or a Hollywood movie. That's now become the ground reality. Recently, I was also addressing an international conference on metaverse where we are trying to analyze the legal policy regulatory aspects relating to metaverse per se. When I create my digital avatar on the metaverse, my digital avatar again could be an intellectual property. And there could be a lot of intellectual property that I could get generated out of metaverse per se. How do I effectively enforce that? uh, I obviously can name my digital avatar, that they could be trademark. I could create some kind of a digital avatar using a code, a program. Therefore, that protection could also be under copyright. I could come up with a process on the metaverse, which again gets capable of protection under patents per se. So, effective implementation of uh, your IP rights on the metaverse also will be a very, very interesting domain. Should uh, in the present situation be given that we do not have any dedicated metaverse laws, but end of the day metaverse is nothing but data or information in the electronic format. Hence the Information Technology Act could be made applicable thereof, and you could look at enforcing the rights under your IP rights, not just from a copyright perspective but also under the intellect and IT Act rules and regulations perspective, to enforce your IP rights on the metaverse. Content licensing, a lot of things are happening across the metaverse content. The licensing on the metaverse has now become increasingly popular. A lot of games, a lot of fashion, and a lot of these events are happening up across on the metaverse. Metaverse branding has now become the latest happening. Metaverse virtual restaurants have already begun registering their intellectual properties in the domain. We've seen McD and also some popular players register for intellectual property rights with respect to their metaverse restaurants. And now it's a very interesting matter how these content and over the metaverse will be licensed? Will the license options being made available to the physical laws, uh, like the license grant, the revenues and the royalties being made available in the physical domain also be applicable to the metaverse domain? Currently, there's a debate, but however, with the current position, you can effectively enforce it. Artificial intelligence and I mean IPR, a lot of legal work is happening across the domain. Who owns this intellectual property which is on the artificial intelligence? Because AI ultimately runs on data and data sets. Ultimately, is going to be the element of big data, and who owns the intellectual property right in the artificial intelligence would be a ticklish question. Whether the output generated by an AI algorithm be subject to intellectual property rights mechanism, would you be able to enforce your copyright with respect to the output generated by an AI system? Will an AI system be considered as an inventor? That's a very, very interesting scenario. How do you adjudicate IP infringement in the domain of AI? How do you enforce your IP rights in the domain of artificial intelligence? Would be the interesting questions that we'll all have to look at currently. The US Patent Office ruled a couple of days back that the artificial intelligence system per se cannot itself, in its capacity, be considered as a legal inventor, because legal inventions can only be done by human beings and not by an AI machine or an AI algorithm per se. This guy is now going ahead and suing the patent office for deciding that AI cannot invent things. So a lot of groundwork is happening. In this case, it will be very interesting to see how the IP rights of an AI algorithm could be enforced if an AI becomes the inventor of the particular IP. That will be a very interesting question. And not just that, when it comes to IP protection, IP enforcement, in terms of artificial intelligence, three ways to look at it: hardware, AI algorithms that you can look at; process and working, you can look at the device or system. You can go ahead and register the patent. And if it's something more than an AI, you want to protect the code of your algorithm, then you can go ahead and effectively register a copyright per se. All these could be essential components how you can protect your intellectual property right in the domain of artificial intelligence, and how you can effectively enforce them uh, practically. So these are all questions that the world has to answer, because the patent would be now again the first inventor of an invention. Patentee is usually only a natural person, and he'll be the person who can acquire ownership. But non-person entities, can AI machines be granted patents or not? This is a very interesting domain per se. And apart from that, there are also going to be legal challenges with respect to enforcement of rights, responsibilities, ownership, capacity to sue, because to sue or to be sued, I think that's a very important domain. And how does the concept of licensing work in the domain of artificial intelligence? That's also IP licenses, where how they could be enforced on an AI. Whether AI has the capacity to permit licenses, that's a very interesting domain. Apart from that, copyright, yes, look at this. The machine is exactly created an artistic work. In this case, the artistic work is capable of copyright protection because it's an artistic work. But who owns that particular artistic work, and how, if it is owned by a machine or an algorithm, how do you enforce your rights? That will be a very interesting domain. Likewise, in music, the other day we were handling a client who had written an AI algorithm with which the basics of music. In our case, in Indian music, let's say the Sarigama Padanisa. So the seven swaras were incorporated into the AI algorithm, and the AI algorithm had the capacity to come up with distinctive tunes and distinctive combination. It's again a musical work. It's again capable of copyright protection. Who owns that particular copyright is an interesting question. Whether it's the AI algorithm or the creator or the coder is another way. If it's the coder, to what extent would we be able to enforce his IP rights will be a very interesting question per se. And this company called Nike has already started to hold a patent for blockchain based sneakers called CryptoKicks. Look at this. Now, the intellectual property right enforcement has already now got applicable to blockchain based sneakers as well. to just coming and to the end of my presentation, just would like to tell you that a lot of these activities, whether it's cryptocurrencies, whether it's 3D printing, or whether it's the wearable devices, or whether it's the Web 3.0, whether it's Internet of Things, I think a lot of intellectual property gets generated, and it's very, very important that we go ahead and protect these, and therefore enforce the IP rights per se. So with this, especially I'm almost walking to the end of my presentation today, and let me see whether I can just once again share my screen. Is my screen still visible? Participants, is my screen visible? Okay. And even title, look at this fabulous movie called Sholay. And again, RGV, who's known for this kind of controversies, came up with this title called Ram Gopal Verma Ki Aag. He had to again change, because this is again enforcing of his IP rights, which is attached to this particular name called brand name again. So therefore, this is again a filmy episode, but I believe that these are all just instances with respect to the same. Harry Potter versus Harry Potter. Yes, Warner Brothers tried to do something, but it's a very interesting judgment. If you sleep over your intellectual property rights, you can no longer enforce the same. So therefore, that's a very distinctive view taken up by the Delhi High Court. And Guruji.com, this is another search engine which actually tried to come up with, a copyright issue. T Series were suing them, and this website was hosting all sorts of music files, which is belonging to the copyright of T Series. And this particular domain owner was arrested. Criminal case was filed for IP infringement, and a non-bailable warrant was filed. And he was not get successful in getting bail for the same. So I believe all of these are just wake up calls. I think we just need to understand how you can effectively enforce your IP rights, how you can protect them. And this is one last case, which is G Films versus Sundial Communication. Sundial developed the idea of a TV series called Kush Kahani, and they approached the managing director of Z. They shared the concept note where the basic plot and character sketches were outlined in confidence. Later, it found that there was a TV series called Kahaya, which was broadcasted again, and this was very substantively similar to that of the Sundial. Therefore, Sundial went ahead and exercised their legal recourse and legal remedy against Z Television. They sought for an injunction, and at this order, a single judge granted an injunction. In the appeal, the Bombay High Court opined that an average person would be able to, who would definitely be able to conclude that these films was based on this particular Sundial script. So therefore, it also treated that the execution of this idea. Look at this. This is where I was just wanting to tell you. Ideas are not protected. Execution of ideas is protected. Since they listed all the basic plot and characters sketches on a concept note and shared the same, the favor, judgment was given in their favor per se. So then sharing is caring, but now sharing is absolutely illegal here. So therefore, this is the importance of intellectual property rights, and therefore, I'm just trying to wind up my presentation per se. So what is necessary is only what is required. And I believe in the short span of time, I try to touch upon different aspects. So thank you, ladies and gentlemen. With this, I almost come to the end of my presentation. Thank you, organizers, for giving me this wonderful opportunity. Thank you, participants. I'm open to any of the questions that you have. We can discuss.
Dear participants, if you have any question,
you can unmute yourself and ask the questions, or else write it in the chat box.
Hello. Hello.
Yes.
Yeah. Hi. This question is for Advocate Sushant. So the thing is, if we register a domain name,
Your voice is not audible. Could you be a little louder, please?
yeah. Am I audible now?
Yeah. Please be a
Yeah.
little
Okay.
little more louder.
Yeah. Sure. So the question is, if I register a domain name against
Okay.
my, say, could be a trademark or could be my company name, and if it is associated with that name is also associated with my email address. Right. So is the domain
Okay.
name, email address, or the email data is part of the
Okay.
intellectual property?
Yes, definitely. Why not?
Okay. And if somebody deletes that, that email ID or the data associated with it, so is that infringement of my intellectual property?
Yes, definitely it is in violation of your intellectual property.
So how do I claim and enforce it? I mean, is there a way to get an legal remedy?
Definitely you can look at it. One second. Yeah, I'm so sorry. Yeah, please go ahead. Definitely, you will have a legal recourse because should you want to get compensation as a result of the same, because that is where I said if you're using your email ID for your business activities or professional activities as a result, because of somebody deleting it and taking control over the same, you will also be suffering certain kinds of damages. So you can go ahead and exercise your civil remedies, go to a court, and then get an injunction order like I was just trying to tell you about by way of damages. And if it can be proved that the other person did it with an intention, then you could also look at criminal remedies as well.
So when you talk about civil and punitive
Yes,
damages, how do you
yes.
calculate those damages?
How do you?
How does one calculate that kind of damages?
Yes. So it is basically, looking at what kind of, there's an IP valuation that is done usually. Getting calls, so when my voice gets, is getting disconnected. 1 second. Yeah. So your question was, how does one value the data or the compensation, correct?
Yes.
Okay. See, two things could be looked at. First thing is that data could be valued. That is something that we'll be looking at. Then the second thing that you'll be looking at is that what kind of a loss or a damage that you can suffer. If that would be actually quantifiable by way of money, then you could actually seek, compensation monetarily to that extent. Let's say because of this kind of damage, I'm actually suffering certain kinds of damages with respect to my profession, for example. So if I can validate and say that because of this could be the average monetary compensation or quantifiable damage, well, that is what we call in law as something which is accountable, which is not accountable by money, basically. So if it is something that could be quantifiable under money, then I could be definitely able to, showcase to them that, see, this is my average revenue that I would have got, and this is the average damages that I could suffer because of this kind of an activity. Then that could be looked into, and appropriate compensation could be awarded by taking that into consideration. Not just that, if the kind of activity is very repetitive in nature, then and that could also be looked into while granting the compensation. These could be the 2 pointers that they will be looking at while granting compensation.
Sure. Thank you. So Sushant, can I contact you after the seminar ends? Because I
Sure,
need to
definitely,
discuss. Yeah, sure. Okay. Thank you.
definitely.
Thank you.
Next question, please.
There is one question from the participant.
I'm sorry, your voice is not audible.
Pankaj Kumar, he is a journalist. Time it needed to such litigations.
I'm so sorry. I mean, voice is not clear. I mean, could you type it? Otherwise, I'll take it from the chat. Generally, how
There
much
is a
time it is
question
needed to
from Pankaj
settle
Kumar.
litigation?
Generally, how much time it is needed to
Okay.
settle such
Well, it
litigations?
depends upon the kind of remedy that you're seeking for. See, if you're looking at a civil remedy, then probably you can get an instant, you can get a temporary injunction, which can happen within a very less amount of time. Because you can go ahead and immediately get an injunction, because the injunction application will be filed such that, putting forth the urgency. And if there is no injunction order granted, then further damage or further damage you could suffer because of that. So thereby, that could be the kind of application that you would ideally be filing to get immediate release. Or else you could also, if you're looking at something which uh, takes a little more longer time, you can actually put up all your evidences and try to establish the fact. Just typically wanting to file a criminal case, that requires a little more time, because you should gather the evidence, and you must be able to demonstrate that there was an intention of let's say to damage, or intention to cause do something in a fraudulent manner. But to get a civil remedy, and specifically a injunction order, if you can move an urgent petition and establish the fact before the court that unless an injunction order is granted immediately, my damages will still continue, and the court will to take that into consideration and issue an injunction order temporarily. So that's something that you can look at. So I hope your query was resolved. Yes, can we have the next question, please?
Anyone else, if you have any question, you can unmute yourself and ask.
I'm sorry, I'm not able to hear you. Could you be a little bit louder, or could you message the chat box?
If anyone have any relevant question to IP enforcement, you can write it in the chat box or unmute yourself, or else we'll be ending the first session, and the next speaker will be joining soon, and we'll thanks Dr. Advocate Sushant sir for their valuable insights. If anyone have any question. Okay, I hope everyone else don't have any question. So thank you, Advocate Sushant sir, for providing a very valuable insight on IP enforcement, how it is, how litigations are carried out for IT firm, regarding IT laws, how it is included in our nation, right? We again thank you on behalf of Saurashtra University, DPIIT Chair, IPR Chair at GNLU, and with support of CIPAM. It was a very interesting session on IP enforcement. Thank you, sir.
Thank you so much. And thank the organizers once again, and also CIPM for this wonderful opportunity.
Thank you, sir.
To all the participants, the next speaker is joining within 1 or 2 minutes. We'll wait for 1 or 2 minutes, and after that, we'll be having the session on IP prosecution.
अनम्यूट करी है गेलो
Hello, good afternoon, everyone. I'm so sorry I'm a little late. I was having some technical issues with my laptop.
Yes. Hello. Very good afternoon, sir. We welcome you on behalf of Saurashtra University and IIC. I would like to request Dr. Ranjan Food to welcome Dr. Rajeev. Okay, ma'am is not here. So just 1 minute.
Thank you, Pat. On behalf of Saurashtra
Yes.
University, DPIIT IPR Chair from Gujarat National Law University and CIPAM, I welcome you, Rajeev Venkat Rambhatla, sir. Rajeev Rambhatla, sir, mainly focus on preliminary on commercial litigation, consumers litigation, arbitration, company law, and regular issues. He has considerable experience in dealing with complex litigation matter and has been a recommended counsel for many multinational corporations doing the business in India and abroad. Rajiv advised a broad spectrum of clients working preliminarily with institutions, private equity funds, PSUs, banks, and multinational companies. He also asked for a number of Indian companies, particularly in the contents of high profile commercial litigation and dispute resolution. With this small introduction, I would like to request Rajiv to deliver his talk on IP prosecution. Rajiv sir, please welcome.
Thank you. Thank you, ma'am. Thank you so much. I have a presentation. Can I share it with somebody? Can I just start?
Sir, just one request. Please speak loudly. I'm not getting proper voice.
So, am I audible now, ma'am? Is it better?
Yes, sir. Little bit.
Yeah. Okay. I'm so sorry. Yeah, I hope it is better now.
Yes, sir. Yes, sir.
I have a presentation which I want to share. I can I think I've shared it with Mr. Sejpal. Can it be shared with everybody, or should I try to share it from my end?
You can share the screen directly if
Sure.
your presentation is on, or else
I'll
if you
I'll just share.
want to
Thank
be.
you. Thank you. Uh, I hope it is visible to everyone.
Yes, sir.
Just visible, sir.
Okay, great. So, good afternoon to everyone present here. And firstly, please accept my sincere apologies for being a little late to the session. I had a court session in the morning, and from there to come to my office and start the session, it took me some time. Real apologies, and I had some technical issues with my laptop, which didn't help either. Uh, so, having said that, good afternoon to everyone, and it's an absolute pleasure to be here. And today I will be giving um, a session, or I'll be conducting this 1 hour session on IP prosecution and the nuances that are involved with IP prosecution in India. So, without wasting any further time, let us please move on to the first slide. Okay, so the first question when we talk about IP prosecution that comes to our mind is what is IP prosecution, right? Now, IP prosecution essentially it encompasses the interaction and the negotiation between the two parties, that is the applicant and the IP authority. And IP prosecution is often confused with what is known as IP litigation. And through the course of this presentation, we'll see why that is not the case. Now, let us see what IP prosecution is usually used. It is used for patents, copyrights, trademarks, design rights, or plant variety protection, or even geographical indications. Now, IP prosecution, essentially, if you look at it, it is the process and the interaction that takes place between an applicant who's trying to get certain IP rights. Now, these IP rights could be in the form of patents, it could be in the form of copyright, it could be in the form of trademark, it could be in the form of design rights, or even plant variety protection or geographical indications. Now, these are common types of IP that we're all aware about. Now, when we consider these classes of IP, there are certain authorities like the patent office or the trademark registrar or the copyright registry that one would need to interact with for obtaining or for registering these rights. Now, sometimes there can be a pre-grant or a post-grant prosecution, depending on at what stage the prosecution is happening. So that essentially what happens is the process does not end with the registration of the IP itself. Now, it is always, as I was saying in the beginning of my introduction to this slide, IP prosecution is often confused with IP litigation. But in reality, both are entirely different concepts. Now, IP litigation arises between private parties, for example, between the IP holder and someone who infringes or abuses his right. Right? Now, usually patent prosecution it can be either classified as pre-grant or post-grant prosecution. So the essential difference is that patent prosecution is the process which involves the IP holder and the authority, whichever authority it may be, depending on the class of IP. Whereas IP litigation generally it involves the IP holder and someone who infringes their rights. So it is usually between two private parties and not with the authority that is issuing the IP in itself. Now, coming to pre-grant prosecution, it is essentially the process of arguing or negotiating beforehand with the patent office for the approval of a patent application or a sorry, can I continue? Hello, am I audible?
Yes, please continue.
Yes, sir.
Yeah, sorry. I think I was muted by mistake. Yeah. So I was saying now this is different from a post-grant prosecution, which it is essentially the issue that involves an amendment or something that happens in a situation after the grant has been issued. And such opposition proceedings usually result in cancellation of a patent or an IP right that has already been granted by the authorities that I was mentioning. This is essentially the difference between IP prosecution and IP litigation. And within IP prosecution, we have post-grant and pre-grant prosecution. Now, having this background, let us look at the second slide. Now, pre-grant prosecution, it involves drafting of the patent application, the claims, filing with the patent office. Now, here I have only taken the example of patents and speaking about patents, but this could also apply to other classes of intellectual property as well. So basically, the coordination or the interaction which happens with, in this example, the patent office, right? That interaction is what constitutes your pre-grant IP prosecution, especially at the stage of, especially before at the stage before which the IP has been registered, which is why it's called a pre-grant prosecution. Now, what we have to keep in mind while looking at pre-grant prosecution and post-grant prosecution is that the difference between the two procedures is what ideally distinguishes these two at a level of various classes of IPs. Now, here I'm talking about patents, but this could also apply to copyright registry. It could apply to uh, the trademark registry, or it could apply to any other authority which is dealing with intellectual property, or which is the authority to which one applies for registration of an intellectual property right. Now, the goal of on the pre-grant side is to get the patent granted and secured completely. Right now, we have to remember that pre-grant prosecution, the ultimate aim is to get the patent granted or the particular IP registered in favor of the IP applicant, which is where the entire procedure of pre-grant prosecution effectively starts. Right now, there are certain steps here when the application is actually filed. Here again, I'm taking the example of a patent. So first, there is the disclosure of the invention. That is, a non-disclosure agreement is usually signed between the professional and the inventor, and thereafter, the details of the invention have to be given incomplete, so that the next steps can be taken. Now, the second step is to search whether this invention is patentable. Then, at this stage, there is usually a search that is conducted by the professional, and that is when it is examined whether or not such an invention can be patented in the first place. Now, the step three is the decision to file an application for the patent. Now, this is one of the most crucial stages because it marks the beginning of the filing of application to get a grant. Again, I'm referring to a patent. Now, in this step, after searching whether the invention is patentable or not, there is a decision that the applicant makes as to whether the patent application has to be filed or not. This decision revolves around the provisions of the Patent Act, which determine whether the invention is patentable in the first place itself, as I was saying. The fourth step is to draft the patent, and this is also a very crucial step because the application has to be very well drafted, and one has to ensure that all the procedural requirements are being complied with in order to ensure that the same is granted without much hurdles. Step 5 is filing of the patent application. This is pretty self-explanatory. Step 6 is a request for examination of the application. Step 7 is replying to objections raised, if any. Usually, in most situations, we've seen that some objections are raised at some level or the other, and usually this is where the most amount of time is consumed. And once this step is dealt with, step 8 is, of course, getting the grant of the patent application. And step 9 would be renewal of the patent. As we all know, it will be a valid patent that has been issued, will be valid for 20 years, and thereafter we proceed with renewing the same. So these are effectively the 9 steps that are involved at the pre-grant prosecution stage, and these are what I think we need to keep in mind, and these constitute an important part of the or the rather the entire part of the pre-grant stage itself. These are the steps that I was mentioning as we spoke. So just to quickly recap, disclosure of the invention, check for patentability, patent proposal, publication, pre-grant opposition, which is the objections that I was mentioning, examination of the patent application, grant of the patent, post-grant opposition again, and duration and renewal, which, as I mentioned, was in India is usually 20 years, and then renewal on expiry of the first term. Now, let us more closely examine what are the kind of inventions that can be patented. Now, sections 3 and 4 of the Patent Act obviously define inventions that cannot be patented. Now, this involves inventions that are frivolous or contrary to established laws, or in inventions which the use of which would be contrary to public policy or morality, so on and so forth, right? So there are various such inventions that cannot be patented. Now, we have to look at each one of these a little more closely in order to understand what are the kind of inventions that cannot be patented and the ones that can. Now, obviously, number one was inventions that are frivolous or contrary to well-established laws. Inventions, the intended use of commercial exploitation of which would be contrary to public policy. a discovery of a scientific principle or formulation of an abstract theory or any living or non-living substance that is occurring in nature, something that is already there basically. A method of agriculture or horticulture because it is supposed to be of use to a whole community at large. Any process for medical, surgical, curative, again for the same reasons. Any diagnostic, therapeutic, or other treatment of human beings, or any process for a similar treatment of animals to keep them free of disease or increase the economic value in terms of a product. Biological processes for the production or propagation of plants and animals in whole or any part thereof, other than microorganisms. Algorithms, mathematical or business method for a computer program. A literary, dramatic, musical, or artistic, or any other aesthetic creation. A scheme, rule, performing mental acts. Obviously, because some of these are covered by other classes of IP, they do not need protection by way of a patent, and that is not the purpose of patents being issued, right, for literary work or for musical or artistic works. Now, lastly, an invention that in effect is traditional knowledge or that is an aggregation or duplication of known properties of a traditionally known component or components. Now, what traditional knowledge basically is that something that has already been around, it cannot be aggregated or put together, and something that is derived out of it cannot be an invention which can be patented. It has to be novel, right? Something being novel is one of the key ingredients for a patent. So it has to be a new process or idea that did not exist before in any form. Moving on to the next slide. Now, we looked at the steps that are involved in the process of applying for a patent. We looked at one of those steps being one of the steps being objection for the patent being registered. Now, let's look at some of the grounds why such a patent can be objected to. Now, some of these grounds, as you can see on the screen, errors in the specification, informalities in the application, missing application related forms, non-payment of fees, other non-technical objections such as excessive number of claims. So let's keep in mind that at this stage, the objections that are being entertained are only procedural or non-technical objections. So either any grammatical, spelling mistakes, typographical errors, any extras that were supposed to be affixed that are missing, missing signature on one of the pages, non-payment of the fees or payment of part fees. These kind of procedural non-compliances are essentially what form the grounds at this stage of the patent application process. And let us also look at some case laws here, which basically talk about the pre-grant prosecution stage. And let's look at an Indian case law first. So, Bayer Corporation versus Union of India. I will share the full citation and maybe a copy of the judgment as well. Maybe subsequent to this call, I will share it with Mr. Sejpal, and he can pass it on to everybody. Now, this case, it's a very interesting case that was attempting to create controversial drug patent linkage mechanism as was provided in the US to the legal regime in India. Now, Bayer Corporation, instead of filing a suit for infringement, they filed a writ petition before the Delhi High Court, asking that the applications for Cipla-Soronip, which was one of its flagship drugs, they allegedly infringe its patent, which is Cipla-Soronip, the patent and the patent for the formulation as well, which is owned by Bayer. Now, there was a marketing approval application under the Drugs Act, which ideally should not even be processed or entertained, but it was, which is why Bayer moved to the court. And it was for the first time in India that an attempt was being made to link a drug approval to patent infringement. And the Delhi High Court, however, denied the injunction to Bayer, and they imposed a substantial cost of 6.75 lakhs under the Drugs and Cosmetic Act, read with Section 48 of the Patent Act. And because they wanted to, the essential reason for imposing such a heavy cost was to ensure that any such future attempts to form such a linkage are deterred. And the Supreme Court, as I was saying, pointed out that Section 2 of the Drugs and Cosmetic Act, read with Section 48 of the Patent Act, it establishes a patent linkage mechanism under which no market approval for a drug can be granted, and if a patent was subsisting over that drug. It also claimed that Ciplasoranib was a spurious drug as defined in the Drugs Act, for which market approval cannot be granted under any circumstances. Now, this whole case basically shows that patent infringement cannot be presumed just because there is a drug which the name of it sounds similar, or because it has a similar formulation, does not mean that inherently there might be a violation. Sorry. As I was saying, there might be there might be a violation of any other class of IP, but not of patents as such, which is why this was a very interesting judgment and an interesting verdict that was delivered by the Supreme Court. I will share the judgment copy and the details of the case law post the presentation as well. Okay, now what are the guidelines for an IP prosecutor, or what is it that one should keep in mind? Now, especially at the pre-grant stage, as I was saying before, most of the objections are non-technical in nature. So it is important to have a fine eye for details. One needs to be able to look at the nitty-gritties and ensure that everything is in place, because even one procedural non-compliance could result in an objection. And it's best that over a period of time, if uh, details and and compliances can be paid attention to, then the need for objections being raised does not even arise. Keeping in mind the perspective of both the applicant and the examiner. Now, this is where professionals or prosecutors have to be able to judge both sides, or rather, be able to put themselves in the shoes of both the applicant and the examiner of the patent or the concerned right. And one needs to be able to imagine how best the application can be presented so that it is approved with least pushback. Finding loopholes in the actions of the appropriate authority. Now, sometimes if decisions are not going in a certain way, um, it is important for us as prosecutors to be able to find loopholes, or find more than loopholes, I would say, to find instances of default on the part of the appropriate authority, so that the necessary action can be taken to basically try and get us as close to the grant as possible. Understanding and working on the weaknesses of the applicant's case. Now, every prosecutor, every professional will definitely, after a period of time on perusing applications, will instantaneously uh, have some instincts about how strong or weak that particular case is. And I think as professionals, as prosecutors, it is important to understand and especially work on those weaknesses when they are identified, and try and help the applicant build as strong as an application as possible. Now, use of case laws and examples obviously helps, and it is very easy for people to understand concepts as well when it is substantiated with enough examples and then case laws. And breadth of claiming and specificity in writing, of course. So when the claims are being made, it is always advisable to add as many claims as possible in order to ensure that the interests of the applicant are protected, and ensuring that everything that is being claimed is being specified in writing. This is a very important step, and this needs to be done. Otherwise, it could lead to a situation where the applicant is not very happy with the outcome. So this essentially covers the entire pre-grant stage of IP prosecution. Now, what happens in the post-grant stage? At the post-grant stage, also there are certain nuances that we need to keep in mind. And usually, what happens is after the post-grant stage, or after the stage at which the grant has been accepted and it has been given to the applicant, there are one of two ways it can go. And in the event of a rejection, we also need to keep in mind what are the prerequisites that lead to the rejection of a patent application. We look at the case law of Agribot International LLC versus the Deputy Controller of Patents and Designs. But before we come to that, let us just quickly take a look at the post-grant stage of IP prosecution as well. So at this stage, I will take the example of maybe a trademark, because till now we've been talking about IP. So let me take the example. Sorry, we've been taking the example of patent. Let me take the example of trademark, because trademark prosecution has become quite lucrative and high frequency as well. So okay, so in the example of a trademark, at the post-grant stage, sometimes what happens is there can be objections that are raised to the mark, and hello, am I audible? I'm so sorry, I had a connection issue. Am I audible now? Hello, am I audible? Hello.
Sir, you are you able to unmute yourself? Sir, please try unmute.
Yeah, I think now it has worked. Thank you. Sorry for that interruption. Yeah. So I'm able to hear myself in. It is. Yeah. Hello. Still getting that resound. Can everybody else please stay on mute? Yeah, okay. Never mind. I'll just mute my other device. Okay. So coming back to the slides that we were discussing, prerequisites that can be considered while a patent is being rejected. Now, we'll also look at some case laws here, but let us first look at what are the prerequisites. What are the prerequisites before rejecting a patent application? Now, in this particular case law, Agri Board International LLC versus Deputy Controller of Patents and Designs, the appellant's application for patent was rejected by the respondents on two grounds. One was lack of novelty, as I was saying, patents innovations need to be novel or new, and lack of an inventive step. These are the two essential ingredients for registration of a patent. It can also be said that this is one of the prerequisites. We'll come back to that. Now, the contention of the appellant here was that the order rejecting the application was short and it does not discuss the response to the FER that the appellant had provided. Now, the judgment said that the three elements necessary to be considered by any controller before rejecting the application on the ground of lack of inventive step is the invention disclosed in any prior art, the invention disclosed in the application under consideration, and the manner in which the subject invention would be obvious to a person who is skilled in that art. Now, an order passed without discussing these three elements and arriving at a bare conclusion would not be permissible. That is essentially what was upheld in this case law. But if I'm allowed to just read from the text of similar judgment in the Indian scenario, where the Delhi High Court had decided on a matter between Alani Farid versus Assistant Controller of Patents and Designs. I will share the details as well. So in this landmark judgment, the patent application was referring to an IPO with guiding directions that computer-related inventions demonstrating technical effect or technical contribution are patentable, even though it may be based on a computer program. If we recall, one of the inventions which cannot be patented was a computer program. Anyway, coming back, in the present case, was filed before the IPAB, the Intellectual Property Appellate Board, by Alani Farid under 117, Section 117A of the Patents Act, and challenging the order dated 7 February 2020 of the Controller of Patents. And this is a very recent judgment and is very relevant to our discussion as well. And challenging the order of the Control of Patents dated 7 February 2020 and under Section 15 of the Patent Act, rejecting the appellant's Indian patent application number so and so. Now, the patent application was filed in the year 2000 at the Indian Patent Office for an invention pertaining to a method and device for accessing information and services on the web. Now, a request for examination of the patent application was filed in the year 2004, followed by a publication under the provisions of 11A of the Patents Act, which was further amended in 2005. Now, upon the examination, the first examination report raised certain objections that the subject matter did not constitute an inventive step under Section 2(1) of the Act. Now, the response to the FAR was filed by the appellants. However, the second examination report contained objections from for the first report, along with technical objections under Section 3, subclause K of the Patent Act. Now, the appellants did not respond to the formal report, and therefore they deemed to be abandoned under Section 21 of the Act. And because of abandonment of the application, a writ petition was moved before the Delhi High Court for opportunity of oral written hearings because the party believed that they weren't given an opportunity to be heard. Now, the respondents in this appeal refused the application on the basis of an order that was dated 2008, 18 November 2008. And thereafter, an appeal was filed against the said order before the IPAB, which is how the matter came before the IPAB. And the IPAB dismissed the appeal, and another writ petition was filed before the Delhi High Court in view of the dismissal of the above mentioned appeal. Now, I'll share this entire text of the judgment and why this judgment is important, especially in an IP prosecution context, because it lays down the requirements for novelty under Section 3K of the Patent Act, and how patents need to be not only novel but have an inventive step and be different from previously existing patents as well, which is something that is clearly pointed out by the Delhi High Court in this judgment. I'll share the entire text of the judgment and the citation for everyone's reference. Now, one thing that is important to keep in mind here is that this claim that was filed by the appellant here in this case, it basically fell under the definition of a technical effect or a technical advancement under the guidelines of the Examination of Computer-Related Inventions, which is CRI Guidelines 2013. Based on this, the IPAB refuted the respondent's claim of the European Union guidelines superseding the CRI guidelines, and they maintained that the latter provides cogent, latter meaning the CRI guidelines, provide cogent and coherent guidance in terms of indicators of technical effect, and it also enlists indicators for the same, which include higher speed, more economical use in memory, and more efficient database. Now, the IPAB essentially overturned the previous dismissal, and they held that the claimed invention fell under the aforesaid indicators, and it captured the technical effect as mentioned in the guidelines. The IPAB ruled in favor of the appellant here, and primarily only on the ground that the patent application had different objectives and different solutions in contrast to the respondent's claim, despite there being initially being observed that there was no inventive step. So, which is why this particular overturning of this decision makes this landmark and very important case, something that has been a welcome judgment in recent times by the IPAB. So coming back to the topic of our slide, through these case laws, what we can essentially try to do is understand what are the prerequisites before rejecting a patent application, or what grounds it can be rejected. And primarily, we can establish that it can be rejected for the lack of two primary things, which is a novel idea and an inventive step. Now, we're getting closer to the end of our presentation. I will save some time for question answers towards the end. Okay. Now, the IPAB's order in the previous slide, or in the previous case that I was talking about, Alan Farid versus controller of Alani Farid versus assistant controller of patents and designs. How is it a boost to software patents? Now, I was just explaining the entire case and how it was rejected on the basis that is mentioned here. The overturning of the decision by the IPAB is definitely, in my opinion, a boost to software patents. And so, even though the application was initially rejected for lack of novelty, the overturning by the IPAB is definitely a welcome sign for other such inventions which could be potentially novel and game changing. So it is a good boost for these patents to to come about, and or rather these inventions to become about and be patented, and that would ensure protection both to the applicant as well as to the technological community at large. So essentially, I wanted to discuss the case laws and this interesting judgment wherein the IPAB had recently overturned the decision. And I think that brings us to the end of the session. But I will be open to questions if any, and I'd be happy to provide any more additional insights on particular questions, queries that you may have, or if there is anything else that you all would like me to cover, I would be happy to address the same.
Participants, if you have any questions, prosecution, you can unbox.
And IP enforcement was covered by my morning session. Any questions on the case laws we discussed, or the post-grant or pre-grant stages of IP prosecution?
So can you provide your contact information like email ID or phone number?
Sure. Please, my email ID is Rajeev@KSNK, RAJEEV @KSANDK.com.
RAJEEV, right?
Yes, yes. I'd be happy to entertain any questions or any discussions that any of you would like to have.
Sure, sure. Thank you.
And I would request one of the organizers to share the email ID of concerned person at the university with me, so I can share the presentation, the content that I have in terms of case laws and judgments.
Sure, sir.
I'm sorry for the interruption in between. I think there was some technical issue. Unfortunately, my laptop mic was not working, so I had to take the session from my phone. So I was, I think, getting disconnected every time I got a call. Apologies.
Sir, as I see that we have discussed mostly about post-grant opposition and pre-grant opposition for patents. So
Yes.
is it the same thing that will work with design, trademark, and copyright?
Absolutely, yeah. The procedure, more or less, at the post-grant and pre-grant stage is the same. It is only as I was mentioning during my presentation, it is only the nature of the IP which will change. So it could be a copyright, it could be a trademark, it could be a geographical indication, as I was saying. I wanted to spend some more time on each of the individual categories of intellectual properties, but I felt that the audience would already be familiar with that and we would be wasting time, which is why I decided to speak more upon the prosecution and took patent as an example. But yes, the procedure is almost the same for any other form of IP. There might be certain procedural changes, obviously, in the form of a patent. The invention. Sometimes you would need to probably provide a prototype, whereas the same would not be required for a copyright. things like that. So there might be minor procedural differences, but overall, net the processes are more or less the same.
So another thing I would like to know is sometimes they are saying that the food product or basically the recipes or the eatable are patented, and
Yes.
as per our Indian law, it be patented.
So can you repeat the last part of the question? Food products are patented as per Indian law.
So actually is yeah, Patent Act 1970.
Yes, sir.
So
So
I
are
would
you
like
asking?
to know that is it?
Are you asking if the food products are patented as per
Yes.
Patent Act?
Yes.
Okay.
I am just.
So okay, that's an interesting question. Thank you for that. So, food products essentially the process of making food products would be patented. Now, there must be various classes of IP that go into a particular product, right? There is obviously when it comes to packaging and the brand name, there is a trademark, there's a copyright, and all of that. And the product itself, the procedure or the way that product was invented or the way that product is made, the process for that must is obviously must have been patented. Sometimes what happens is it's not necessary that all of these products are patented in India. They might have a valid patent application in another country, which is then recognized thanks to WIPO by various other jurisdictions. So, like for example, with the recognized products, let's say take the example of a commonly packaged food product, say like biscuits, right? Some of them are international brands, so they might have for the procedures or the processes that they follow are the same across the organization, right? So they might have a patent that was originally registered in a particular country and that is being renewed on a timely basis. And of course, with the expansion of their business, they would have gotten similar patents based on the original patent in the other jurisdictions as well. And yes, and some of these products would definitely have a registered patent as per the Indian Patents Act 1970 as well.
So it can be patented, right?
Yes,
in
definitely.
India. Okay.
I was just giving the example of sometimes.
A way of
So your voice was breaking. Can you come again?
that by a process or formulation of manufacturing.
Correct, sir. Exactly. As an invention, if you're able to satisfy the requisites for a patent, then definitely it will be granted and it will be registered as a patent.
And the same thing will act for the soda or aerated water, means blended syrups.
Yes, sir. To the best of my knowledge, for any product, as long as the patent application is able to satisfy that it is a novel idea, it is a novel process, and there is an inventive step. If those two main criteria are being able to be satisfied, then even if the product is a soda or any liquid based product, also, it should not be a problem.
Okay, sir. Anyone else have any questions? I hope everyone don't have any question, and have understood well regarding IP enforcement. Sorry, IP prosecution, and yeah, and previous session about IP enforcement. Now we would like to thank Mr. Rajeev Rambhatla sir on behalf of Saurashtra University Incubation Center, DPIIT IPR Chair GNLU, and with support of CIPAM, we were able to organize this one-day workshop on IP enforcement and IP prosecution. We thanks a lot the speakers about sharing their very about sharing their expertise and experience in the field of IP, its prosecution and enforcement. We are very thankful to you, sir, for being here and giving your valuable time to our participants.
Sure. Thank you so much. It was my pleasure to be here and look forward to many more such.
And one more thing I would like to add, sir, with your permission, we'll be keeping the recording of this meeting on YouTube, so that anyone who is interested to learn, they can revisit the video on YouTube and can attend the session.
Absolutely. That will be great. Thank you. Thank you so much.
Thank you, sir. Thank you, everyone. Now we'll be ending the meeting over here. Thank you, Anna ma'am, for coordinating with us and providing us a very insightful and very experienced experts for these sessions. Thank you, ma'am, on behalf of Saurashtra University.
Thank you. Thanks, everyone.
Thank you.
Okay, we are ending this meeting now. Thank you all.